Orders for protection. They started out this way. What is that? That's where a judge orders somebody to keep away from somebody else, and they can order you to do a whole bunch of other things that I'll talk about in a minute. They started out because when somebody would be harassed, usually it was a female asking for one to keep a guy away from them. They made a law that said, hey, a judge can order somebody to do that without even having a hearing if there's enough evidence from the girl that's accusing the guy of it, or vice versa, that this harassment's going on. What happens? There's two ways to get one in Minnesota. One is if you want to get an order for protection, the petitioner, the person asking for an order for protection, can ask a judge for a hearing and go through the courts, get a hearing, and then present evidence as to why another person's harassing them and why they want an order from a judge keeping someone away. The other way to do it is what's called an ex parte order for protection, and that's where somebody just fills out an application that then a judge reads. And if a judge determines that there's enough harassment going on or enough of a threat, they'll issue an ex parte order for protection, which means without a hearing. And then what happens is the sheriff gets a copy of it, and then they serve it on the person who's supposed to have no more contact, that the judge is ordering to stay away from someone. That person who's being ordered to stay away or stop contact or whatever is called the respondent in these things. And if you get served with one of these, it usually can look like this. This is an emergency ex parte order for protection. If you get served with one, call a lawyer right away, because you've got a right to have a hearing. If someone's trying to keep you away from them, you've got a right to go into court and have a hearing, but you got to do it really quick and present evidence about why the allegations were a bunch of BS and why this order for protection shouldn't be hanging over your head, because it's going to go on your record as far as law enforcement is concerned, and also it'll be a major pain in your life, and it can also lead to future criminal charges potentially. So they're not a good thing to be served with an order for protection. All right, if somebody gets an order for protection, what can a judge keep you from doing? Well, a judge can keep you from doing a whole lot of things. They can order you to not commit any acts of domestic assault, which doesn't mean just hitting somebody, but even if somebody perceives a threat that they're going to be hit or harmed in any way, that would be a violation if a judge orders you not to commit any acts of domestic assault. There are other things. The judge can order you to have no contact with that person whatsoever. That means written, over the phone, text messages, Facebook, emails, writing notes on cars, doing whatever. You can't have any contact if a judge orders you not to have any contact with them. That can be a problem if two people were married and they have a kid together, and now you get served with an order for protection, and now you want to find out from your wife, all right, well, I want to see my kid. And you can't even call her to arrange that, not talking about anything else with her. That would be a violation, just to call to say, hey, let's set up a time that I can see my kid. Or, hey, I need the bank account PIN so I can get some money out. You couldn't do anything like that. That would be a violation. Another thing a judge can keep you doing is from going to your own home. So your girlfriend gets an order for protection from you, or your wife does or something, and you live together, and even if you're the one that pays the rent or the mortgage or whatever, a judge can order you to stay out of your own home and not to be there at any time. So that can be really harsh for people, because where else are you going to go live for a while now? And these orders for protection can even last a couple years sometimes. Another thing they can order you to stop doing is to go to the person's place of employment, where the person who got the order for protection against you. That can be a problem if you work together. If it's a co-employee, a co-worker that gets an order for protection against you, now you can't even go to your own workplace. More than likely your job is going to fire you for that if you can't even come to work. So that can be a problem. Or if you work at nearby places together, that can be a problem. There are some defenses to these things. One thing is that whether you're served properly, there are specific service requirements, and if they don't get you served the right way and in the right time frame, you can make an order for protection go away that way, and us criminal defense lawyers know how to look into that. Another defense to it, of course, is like I said, you have the right to a hearing. Sometimes the allegations are completely made up because you've got a mad ex-girlfriend or something like that. And sometimes people will make those allegations up, and you can go into court and have a hearing and show the judge why this order for protection shouldn't be around and disprove those allegations. Sometimes we decide to do that. Sometimes it's not a good idea. If you're in a situation where you've got a domestic assault case going on against your ex or current girlfriend or wife, and now they get an order for protection and you want to go fight it, sometimes it's not the greatest idea, because You could be responding to allegations in there that could deal with your criminal case, and although technically what you say in there isn't supposed to be admissible in your criminal case, it gives prosecutors a great idea of some things you might be saying later in your criminal case, or what your defenses might be. So it's a tactical thing that you should consult with a criminal defense lawyer about whether to have a hearing on an order for protection. What happens if you violate an order for protection? So let's say the service on you is valid and you didn't have a hearing, or you did and you lost the hearing, and there is an order for protection out there. If you violate that by having contact with them, or whatever the judge says you can't do in this order for protection, the first violation is a misdemeanor, which means it's punishable by 90 days in jail and a $1,000 fine. Those are the maximums. And it's going to be a criminal record, and a judge can then, if you're found guilty of it, can order you through probation, put you on probation, give you a criminal record, require you to go to anger management or domestic abuse counseling, and do a whole bunch of other things. It's going to be a problem for future employment for you. And police, next time they come around, if they learn about you, usually aren't going to be too kind to you if they see that you've got a prior order for protection violation on your record. If you've got a prior order for protection violation and now you get another one within 10 years, that's a gross misdemeanor, which means it's punishable by a year in jail and a $3,000 fine, and all of those other things with probation that I already told you about. And there's also supposed to be a 10-year or a 10-day mandatory minimum on a second violation within 10 years, 10 days of jail at an absolute minimum, mandatory minimum. Third violation within 10 years is a felony. That can carry prison time. It also can carry at least a minimum of 30 days in jail, but again, you could be sentenced to prison for that. And with a felony conviction, of course, comes the loss of civil rights and all that. If you violate an order for protection, a judge can also prohibit you from owning or possessing any firearms or dangerous weapons. Firearms means a heck of a lot more than just a gun. It's other things like sometimes BB guns. Some BB guns actually qualify as firearms. And then dangerous weapons can be in a whole lot of different things beyond guns. Sometimes knives can come into play. I even one time had a judge contemplating whether a hockey stick was considered a dangerous weapon. So it can really mess with your life to have an order for protection out there, and it's something that you should take seriously and consult with a lawyer about right away. If you're charged with a violation of an order for protection, again, there are several defenses to those things. Another thing we look at is sometimes these petitioners who will go out and get an order for protection then actually go and initiate contact again with the person, with the respondent, who the order for protection is against. That's a good defense in a case. Anytime that I can bring it to a jury and say, well, yeah, technically he did answer her phone calls, or he did go over to her apartment to see her, but guess what? She made the call. She was the one that asked him to come over, and now the police found out about it, and he gets charged with an order for protection. That's a good defense, because I don't think many juries are going to be sympathetic in that situation. So there are some defenses for emergency situations and the like. I can't advise you on whether or not that would be a defense in any particular case or list examples. You should consult with a lawyer if you've got any questions about those. Speaking of that, my name is Ryan Pasiga. If you have questions, my website's arrestedminnesota.com, and my number is 612-339-5844.